So make sure again that you know the importance of K, which includes the notices to purchasers that are required to be given to a buyer at or before contract. So again, we're going over seller's additional promises, everything that seller agrees to do. They cooperate to facilitate showings. They will not rent or lease the property during the listing without broker's prior written approval. And y'all, it is really important to go through all of these with the seller because a lot of times they inadvertently do not realize the importance of all of these items, such as the pool requirements and also any leases or rental agreements that they may make about having a tenant move in or out. All of that becomes available to all parties to a contract. So it's very, very important to have that as a part of the conversation with the seller prior to listing. And then also many times I require agents to go in and ask a seller to update their seller disclosure because they've received inspection reports from a buyer and the buyer's terminated. And they have to know that it is their responsibility to have the most up-to-date information on that seller disclosure. So another item under 14, limitation of liability, is that if the property becomes vacant, the seller decides to move out, they must notify their insurance company and request a vacancy clause. There are different statuses of coverage that occur, whether someone is actually occupying their property as their home, or whether they've got it vacant, or whether it's used for rental. So anytime there's been a significant change, they need to make that notification, and you need to be reminding them to get that done. This B is really important to identify to the seller the things that you are not responsible for with personal injury or loss or damage to a homeowner's property. Other brokers, their associates, inspectors, appraisers, and contractors who are authorized to access the property. Sometimes an inspector can damage a property. One time I had an inspector who fell through the ceiling in a attic, and his company had to make good on the repair for the homeowner. Also, we're not responsible for other brokers or their associates who may have information about the property on their website. We can't control that. Obviously, we're not responsible for vandalism or theft. Freezing water pipes, which is especially troublesome in our area during the winter months. A dangerous condition on the property. I've had certain things where people have fallen off steps, or maybe they've fallen through a dock that is located on the lake because of rotten wood. So if you see any of these type conditions, you need to make sure that you are proactive and that you either have signs or you've asked the owner to fix those conditions so that we are not liable for that in any way. Again, you've got seller agrees to protect, defend, indemnify, and hold broker harmless from any damage caused by the seller, negligently or otherwise, arising from a failure to disclose anything or giving out incorrect information. You want to make sure that you limit any interaction a seller has with a prospective buyer. Sometimes sellers can say things that are not in their best interest unknowingly, and it is important to make sure that you tell the seller that you need to be that conduit so that you can appropriately communicate information. We rarely have reason to use special provisions in our listing agreement. So please, if you have something that is really an item that your seller is asking you to place in here, please ask your coach, or you may speak to your supervising broker, Linda Ramsey or Michelle Bippis, or you can also ask me about that. But the Texas Realtors Group does not want us acting as lawyers to draft certain things and special provisions. 16 talks about the default, what happens if a seller does not cooperate. A broker can terminate the listing and exercise any remedies available to them. So if the broker breaches the listing, the broker would be in default, and a seller could exercise remedies likewise. We always have in our contracts and in our agreements that the parties can go to mediation. Mediation is really required for us in the state of Texas, but it is in itself a very costly procedure for all parties. Typically, the cost to hire a mediator is at a minimum about $1,200 or $1,300 for each side. So it's not something that we proceed to do easily. It may be that you can come to a resolution in another way. If a seller or a broker is a prevailing party in a legal proceeding brought as a result of a dispute, the party could be entitled to recover from the non-prevailing party the cost of any attorney's fees. So that is something to really consider if you get into that situation and get crosswise with the seller. Each and every one of these addenda should be considered to be attached to the contract. Obviously, you will have your basic document, which we use for all contracts, which is the IABS, Information About Brokerage Services. That is found on your signature block and on all your social media websites. The seller disclosure needs to be obtained from the seller, and the seller will use a tool called the Seller Shield tool that you need to use. It's sellershield.com to access the appropriate documents for the seller to fill out for their disclosures. They will have a choice of either using the TREC document, seller disclosure, which is short, it's about 4 pages, or the Texas Realtors disclosure, which is about 8 or 9 pages. You cannot direct a seller to use a particular form, either TREC or Texas Realtors. But what you can say to them is you might consider choosing the form that allows you to disclose. Choose the form which helps you do that to the best of your ability. They may self-discover that the Texas Realtor form is the more comprehensive form. We are always required to secure a seller's signature on a lead-based paint document if the property was built before 1978. Anytime you have a listing presentation, you must ask that seller if they have an existing survey. If they do, they have a choice of doing a notarized T47 document stating what changes have occurred since the last date of the survey. Or they can choose a T47.1 document, which asks the same question: what changed from the date of the survey? And for the T47.1, that can be signed electronically, so your seller does not have the burden of obtaining a notary. We've already talked about the mud or water districts. The property improvement district disclosure, which is noted as F, is a disclosure that is obtained from the seller when the seller has an assessment that he or she owes coming from either the county or the city for an improvement that has been done in or around their community. For example, a developer might choose not to build a playscape for a subdivision. Or maybe there are certain sidewalk areas that the developer is not paying for. So the county or the city could agree to levy an assessment on the homeowners to get that paid for, and the homeowners would be responsible for it. So that is what a PID is, and the seller should know about that. These other forms are also ones that you can add. Mineral clauses and contract forms, we don't have too many of those attaching to a lot of our home or our residential properties in our area, but they could still exist. A very important form that you must attach is the on-site sewer form if the property has a septic system. And that is a Texas realtors form that will tie into the Texas realtors form seller disclosure. If the property is in a property insurance area that has been hit by a lot of storms, hail, you may want to attach that. Similarly, the flood hazard area would also be important to add. And here we have the approval to utilize what they call a key box, but in our world, we usually call that a lockbox. So you would have to have approval from the tenant to place a key box or lockbox on the property. And O is actually the seller's authorization to disclose and advertise the concessions that we talked about, which was in the note under the compensation paragraph. The agreement of parties, number 20, is a lot of legal information that states it's the entire agreement. They can't assign the listing. The listing is binding and effective to those that are party to it. It's joint and several, meaning all sellers are liable for the performance. If you have any other notice, you have to have it given to the appropriate party. That appears in paragraph 1 of the agreement, which is why it's so important for you as a listing agent to secure the proper location for the seller to receive mail and or email. All of these other notices down here are part of this listing agreement. It speaks to the fact that we must comply with fair housing rules and not be discriminatory. It states that the broker advises the seller to contact their lender to secure payoff information. It states that the broker advises the seller to review the information in advance for publishing anything on the MLS. So again, if you finally have everything loaded into the MLS as inactive status, you should send a copy of that inactive MLS listing to your seller and have them sign off on that. It speaks to the fact that a broker can advise a seller to consult with an attorney before using any kind of a surveillance device. You may not know this, but in the state of Texas, it is not allowed for us to have, or any party, to record someone without their knowledge or consent. So if your seller has security devices that are in effect on the property, they need to make sure that they turn off any sound. They could keep the photos on, but they cannot have any sound. Again, we talked about having certain requirements comply with local ordinances or statutes. Under F, that's really important with swimming pools and septic systems. We talked about the lead-based paint law. And then under H, this is not for us to determine, But if a seller is considered a foreign person, the buyer may be required to withhold certain amounts from the sale proceeds. And I have had some disputes wherein a seller believed that he was not a foreign person, but it turned out he actually was. And there was a problem with the buyer at closing. So this is something that you need to notify your seller about, that they should seek information from a tax professional or an attorney concerning this matter. Going down to I, this is very important and is the reason why we have the seller sign off on the wire fraud warning. Many sellers who are approaching closing receive very carefully worded emails requesting that money be wired to certain places. It is almost inconceivable to think that some of these emails are actually scams, because there could only be one letter that may be off in the entire email. So you need to make sure that the seller knows they should never, ever, ever wire any money or take any personal information of theirs from bank account numbers or other financial institutions to other parties that they do not know. The only person that they should be speaking to in the process with wiring instructions or anything like that would be someone from the actual title company that they are working with. Finally, this is your last warning to the seller, which is that we cannot give legal advice. You should always encourage a seller to obtain legal advice if they have any question about any aspect of this listing agreement, and that should be where they go to seek that information. So down here over to the left side is where you would print your name and your license number. You would print out your seller's name. Again, if you have 3 or 4 sellers, you may need to have an additional addendum attached. Over here on the left side, you would then sign. And over to the right side, you would have the seller's signature as well. Now, if you are, up here, you would have Keller Williams Realty and our office number. I apologize. Keller Williams Realty here, 9010968 would go here. Then down below, you would have your signature, and then below you would have your full name. So that is it for the listing document. And then over here, we're going to cover the unlock form. Let me get this up for you. So this form, this document came into effect last summer if you are a member of the Austin Board of Realtors. And like I mentioned, if you're a member of a different board, such as MetroTech, SABOR, or maybe even CTX, it's possible that you may have a different format, because many of the other boards are also instituting what is kind of called an off-market listing. So you should read through this form very carefully. It goes into how you can have what is called a flex status before you put the property on public marketing. But you need to very carefully understand there are some nuances in this form that may be very confusing to you and to the seller. I would invite you to please do a training on flex listings on the ABOR website. They have some videos on it right now, and it will help clarify these different categories for you to use. So here, if you look at this, it's talking about giving the seller different tools for offering their property for sale to various, could be certain parties such as agents only, or it may be just within house, within your brokerage. It can provide many different options for a seller. So your first choice here is to do the full MLS listing, which is here it says includes full listing data, activates the listing in the MLS. This option complies with all clear cooperation requirements. Remember, clear cooperation requirements state that within a certain number of days, a property is to be put on the market to comply with MLS rules. And for us, that's 1 day. So you can choose that here. Then the phased approach is what occurs in number 2. Now, this is where a lot of the agents have been frustrated because sometimes in this flex listing, these flex listings may appear on some other websites. And we're not quite sure exactly how that's happening, but I have had some agents report that. And you want to make sure that you make your choices here very clearly. So here you would know that you have to state it's excluded from the internet display entirely, or you're going to have it on virtual office websites only, or are you going to display it on the listing brokerage or the agent website only? So these are the different choices that you have with flex listing. And again, it's not full print right now. I know that at least in 3 to 5 cases, I've seen where this has not happened the way the agent or the seller believed it would occur. Now here, under number 3, you have the listing broker and the agent may only share the listing within their own firm. And we have a way of doing this within Command. So that is an option for you to do where it would just go to our brokerage, which would include Northwest, Southwest, and Lake Travis. You would not have any public marketing, no signs, no flyers, no website, social media, or mass email. It's strictly internal. So here you would have the seller say, seller acknowledges that they may receive less exposure and potentially fewer offers. You would have the seller check that box. And this form should be addressed with your listing agreement. So if they don't want to do anything different, then you would have them choose number 1, which is the normal way that we would put things in the MLS. I do not, as a broker, have to sign this. Many of our agents have asked me that. I don't sign all of your listing agreements. So along the same lines, because this is an addendum to your listing agreement, I'm not going to sign all of these for all of the agents in the office. So as long as your seller's name is on it, your name is on it with your signature and our brokerage name, Keller Williams Realty, that is sufficient for your use. So that's the end of our listing class today. And I thank you for being a part of this. And I hope this will help you with your multiple listing appointments. Make sure you include all the addenda that I pointed out to you to use, including this unlock form. Thank you.